National Assembly Speaker Thandi Modise will announce her decision on the process to remove the Public Protector Advocate Busisiwe Mkhwebane after a panel concluded its work. Modise appointed the three-member panel that includes retired Constitutional Court Judge Bess Nkabinde and Advocate Dumisa Ntsebeza last year to determine the evidence against the Public Protector. Professor Dirk Kotze from the Department of Political Sciences at Unisa joins us now. A very good evening to you, Professor Kotze. Thank you so much for speaking to us. So, we'll talk about the evidence, but just in terms of the decision, what does the Speaker have to take into consideration?
Well, first, this is the first step. The Parliament has come to an agreement about the procedures that have to be followed with respect to this. It follows very much the same procedures as that of the so-called impeachment of a president. So this was the first step of having first an external panel of three. The next step is that a committee from Parliament, a multi-party committee from Parliament must be established. So it will be consisting of both ANC members as the majority, but also from the opposition parties. And then they must go through the report of the panel. So it's not so much really about whether what is the next step. That has been established already. And that's now one of the rules of Parliament. It's rather about to what extent the conclusions of this committee is sufficient in order to say there's grounds for the next step. But I think that's more or less a given. So we can expect that very soon the Speaker will announce the formation of the Parliamentary Committee of Investigation.
So, as I mentioned in the introduction, that the report will be made available in this week, but the evidence before the panel, what issues were they ventilating in order for them to advise the Speaker on the next step?
Well, I obviously haven't seen that report, but I think what they would have done is to accumulate all the evidence that they could find that is either in favor or against the Public Protector. They would have weighed up the pros and cons of the evidence and what's the evidence in favor of her being acquitted from this process and those that says, well, the process must continue. They will then come to a conclusion with a recommendation to the Speaker and by implication to the Parliamentary Committee. My expectation is that there will be overwhelmingly a lot of evidence, very much based on what has been pronounced already by the courts. Several court judgments referred to the capacity or incapacity of the Public Protector. And I think they would have summarized and brought them together in the form of a report that will form the basis of it. And then set out what, on the basis of what the Constitution provides as the grounds for dismissal of a Public Protector, then lay out the evidence to Parliament.
When the Democratic Alliance tabled the motion last year to remove the Public Protector, it was labelled by detractors as being politically motivated. Now, I want to hear from you, how possible is it to remove the politics from this? As you say, part of what is being examined is the result of court judgments, findings on, if one were to look at the Reserve Bank case, for instance, findings saying that the Public Protector was dishonest. And there have been instances where it was said that she doesn't understand the legal principles, but some of it obviously has been paraphrased for political battles. And again, this is why I ask the question, is it possible to remove the politics from this?
To some extent, no. Well, it started, I would say, first of all, more as a party political approach by the DA. But I think subsequently it has broadened, and that many persons in the ANC maintain the same position as the DA. The fact that the Speaker, although she is supposed to be independent and non-biased, the fact that she allowed this process to continue already gives us an indication that the ANC is not completely against it. The only party really that has been in the past very much in favor of the Public Protector or trying to protect her is actually the EFF. So in that sense, I think there is more than simply a single party like the DA that's pushing this agenda. It is certainly more parties. Some have made quite a number of the smaller parties like the UDM and others are also in favor of this process. So it has become, there is a bit of an alliance or coalition of parties that are actually in favor of this.
Is it a poisoned chalice of sort? I mean, the public protector herself has gone to the High Court to block the process, and she has lost that first round of the battle. But is it a possible indicator of how things will unfold, given that she's already faced, as we mentioned, several court battles over the last few years, and some have said it could even have poisoned public opinion against her?
Yes, well, that is certainly the case. I think we know already what is the opinion of the courts about her. I think what is now the next step, and that is what makes this process, this parliamentary process, a bit more political in its nature, is the fact that the whole process will be managed by politicians, by members of parliament, and not by lawyers, and not with an ultimate judgment being presented by a presiding officer who is a legal person. So in that sense, there is certainly a political component to it. What we've seen not long ago, for example, in the US with the second impeachment of President Trump is something like that. It's something similar to that. I think here it is less polarized than, for example, in that case. And there will possibly be, there's more of a bigger sort of convergence of ideas, of opinions about this than the polarized position in the US. But it essentially, in the end, is a process which is not a purely judicial process, as, for example, a court case or a disciplinary hearing which faces which you.
Is that problematic? And I'm just thinking, as you mentioned, that the people who will be presiding over this are not necessarily legal minds. So let's look at, in the court of public opinion, what should the layman take into account when considering this issue of her fitness to hold office, when weighing up these accusations against her, that she is poor at her job? The National Prosecuting Authority has preferred perjury charges against her. So I'm just saying, is it possible for the public to be able to look at this with a sober mind without being emotive as a result of the bickering and the jostling and trying to put her in a box, so to speak?
Well, I think if it comes to the public, it's very unlikely that it can be an unbiased, very, as you call it, sober sort of approach. The public always has its own views, and that's not most of the time not based on a very sort of clinical legal process that leads to that opinion. It's rather about public opinion in general, which is very often based on opinions of persons and on what they regard as good or bad, but not from a legal point of view. It's rather from an opinionated point of view. And this, it will apply to this case again. I think that is why this first step was so important, because this is the legal input into this process. And it is supposed to lay the foundation for the rest of the process. So most of the investigations is supposed to be based on this report. And that is why it is so important that it comes from persons with quite a lot of credibility in the public eye as well as in the legal fraternity.
So she is in tandem going through her own court challenges. What will be the effect of this for her to also be able to mount a convincing defense on her behalf?
Well, in the end, the decision of Parliament is the final one. This is the constitutional position. The Constitution gives Parliament the right to appoint and to remove members or persons incumbents in the office of the Public Protector. So it's a constitutional process. And this is the one with the highest authority. So it will overtake decisions taken by Parliament. The Parliament cannot, for example, in the end, set aside such a decision by Parliament, or the courts cannot set aside, except if there's proof of procedural problems that the Parliament hasn't followed its own procedures. But when it comes to the merit of the decision, that will be Parliament's decision.
All right. Thank you so much for your time and insights, Professor Dirk Kotze from the Department of Political Sciences at Unisa.